Welcome to our segment today on all things evictions for landlords and learn about the process of an eviction and how to make sure that they're doing their eviction properly. Today we're here with Andrew Griffin. He is a California attorney. He's been practicing for over 35 years, and I'm your host today, Pamela Macias. Today we're going to start with a 3-day pay, run, or quit. And so many of our clients call us and they say that they've started the eviction themselves by submitting and preparing a 3-day form. But a lot of times there are so many online forms that are not up to date or don't have the proper formatting to be accurate. So today we want to discuss a couple of things with you and how to make sure that that form is completely bulletproof when you get into court. So tell us a few things as far as the eviction notice goes, and what are the options that a tenant has when they're served with a 3-day pay, run, or quit?
Well, I'm glad you asked me about this because many times people will go online and get forms that they think is going to satisfy their requirement of giving a 3-day notice. The problem with online forms is that there are so many jurisdictions, 50 states, and each state may have different requirements for giving eviction notice. And in this particular case, in California, and this is what we're talking about today, is California, is a 3-day notice has different requirements. So usually we give a 3-day notice when a person or a tenant is past due in his rent. Now they have the option to pay within 3 days. If they don't pay within 3 days, then the landlord is able to file a complaint, an unlawful detainer or eviction complaint.
Okay, and is there anything else? I know San Diego has an ordinance, certain requirements that need to be followed when doing an eviction. Are those things that maybe a landlord needs to kind of be aware of?
And I thank you for bringing me that up, because not only are different states have different requirements, different counties and different cities have different requirements. For example, the county of San Diego, if you're residing in the county of San Diego outside the city limits, then there are requirements. They're not the same requirements as if you're in the city of San Diego. So not only do you have to give a 3-day notice and the requirements in 3-day notice, but you also have to specify the San Diego Municipal Code that you're violating if a person has been in that city of San Diego residence for more than 2 years.
Got it. So definitely need to be aware of that. And does that change the notice at all?
It does change the notice, because you not only do you have to give a notice pursuant to the California rules, but you also have to include the municipal code in the notice.
Wow, so you really have to know what you're doing, because I'm sure that those free forms don't specify as far as the city or county and those specifics there. When can a tenant be served with a 3-day pay, run, or quit?
Well, all that depends. It depends. Some rental agreements provide for a grace period. Mm-hmm. So, for example, if you have your rent due on the 1st and you're not late until the 5th, that's the 5th of the month, and then, if I don't have to give you the rent until the 5th day. Mm-hmm. So if you're going to give me a 3-day notice to pay rent or quit on the 1st day, then it would be invalid because I have 5 days to pay.
Got it. Now, is there a difference between, say, the late fee and a grace period?
There is.
It's like it's a gray area.
There is a difference. And you need to understand that if I say that you have your rent is due and payable on the 1st, or even late on the 5th, you can incur a late fee, depending if your lease says you can pay a late fee. Now, that late fee still says you owe me the rent plus the late fee. Again, it still doesn't affect the way that you give a notice. If the rent's not due to the 5th, you don't give the notice until after the 5th.
Okay, but for clarification, say if rent is due on the 1st, it doesn't say anything there on the grace period, but yet you have a different clause that says there's a late fee that gets applied after the 5th day. Is that the same as a grace period?
No.
Okay.
No. If there's no grace period stated in the rental agreement, it says that it's not due and payable until after the 5th day, you still have to pay on the 1st, and you can give that 3-day notice on the 1st.
Got it. when you do a 3-day pay rent or quit, can you add that late fee? Or say, a lot of landlords these days, they charge pet rent, you have the water charge if it's a shared meter, parking fees, things like that. Can you add that onto a 3-day pay rent or quit?
Not if you want to lose.
Oh.
You have to be very careful about that. Many times I'll have people come in with these forms, and they'll put on their 3-day notice they're going to quit. Okay, say for example the rent is $1,000 a month, and they have to pay. There's a $50 late fee. They'll say, okay, for the month of January you're late. You're going to pay me $1,050, and we go to court and we would lose. Why? Because you've added that late fee. Now, when you're putting a 3-day notice of pay rent or quit, you're only allowed to put the rent amount. Now, I say it depends because there are some leases that will say additional fee that has nothing to do with the rent.
So pretty much the eviction notice needs to have base rent.
That's correct.
Okay, got it. Now, what are the different elements that a landlord needs to make sure that they have in a 3-day notice to pay rent or quit? What are like the most important things that stand out? Where it's like, if you forget that, it's done.
Okay, well, this is very important to have. On your 3-day notice, each notice has to have the tenant's names. It has to have the rental property address, and that rental property address must be accurate. The name to whom rent is to be paid, the address where the rent is to be paid to, the hours and the days where rent can be paid, a phone number to contact the person who's going to pay the rent, and the amount of the rent owed, and the pay periods. They just can't be lump sum into a pay period and say, oh, you from January to December. You have to have it delineated for which rents and which month and to how much rent's due. The other thing that you could put in there is if you're going to deposit into a bank account, you have to have that information as to where it can be deposited. Especially you want that in there if that's what the normal and custom way of making the payments have been, and in the past of the money going into the account. So make sure that you have all that information accurately described in the 3-day notice.
Okay, and if you do use a bank account, are there certain requirements that a landlord needs to follow when doing that kind of notice?
That's true. There are. For example, I can't say a bank account that's more than 5 miles away from the rental unit. I have to have a bank account that's close to the unit so that they can go in and put the money in.
Got it. And you said that it has to be the customary way to pay. But what if it's one of those really random banks where it's maybe way across town, but that always has been the customary way to pay? What would a landlord do at that point?
Well, I think the landlord should make sure that they have the alternative, have either closer to the landlord or how the landlord's going to get paid, or do it the normal customary way. You should give that option so that you can't say that when we go to court, you say, nope, you violated the rules because the law says that the bank that I can put the money in must be less than 5 miles away from the rental unit.
Got it. So if there isn't one within 5 miles, maybe just say it needs to be mailed?
Yes, you can do that.
Got it. Okay, so at least they have a fallback. They don't feel like they're stuck into that way, like stuck between a rock and a hard place. Okay, so on the pay periods, you mentioned that. Is it always the first? How do you differentiate with the pay periods? How do you list that on your eviction notice?
Well, it's important that you want to make sure that the pay period amount is for the particular period that you're normally being used. For example, if you're normally paying on the 1st of the month, and it's for that month, you want to put from the 1st to the 31st, or the 1st to the 30th, or the 1st to the 20th, depending on which month that you're accurately describing. Now, you understand, just like I said, different months have different amount of days in a month. So you want to accurately say, this is from February 1st to February 28th, or if it's a leap year, you want it to 1st to the 29th. If you don't do it, then there's grounds for dismissing the case and being lost because you didn't accurately describe the amount of rent and the pay period. Do that.
Okay, so from the first day of the month to the very last day of the month, exactly.
Well, again, it depends.
It all depends.
It depends. Now, for example, what happens if you entered the unit, to rent a unit, on the 15th of the month?
Is it the same thing as saying, okay, I entered, or if the due date of the rent is the 15th of the month?
No, but this I was going to say, let's say you entered on the 15th of the month, and your custom and practice was to make sure that you paid on the 15th of the month and to the 15th or the 14th of the next month. Okay?
Okay.
So the pay period would be from the 15th of one month to the 14th of the next month. And you have to actually describe it that way. So it may not be that's when you entered, but if that was what the contract was from 15th to the 14th, or your custom and practice that do it 15th to the 14th, that's the way it has to be adequately broken down in your 3-day notice.
Got it. So like, gosh, it seems so technical. It just seems like you need so much experience to really do this.
You have to be very careful. Be very careful. This is a technical issue. This is a technical process. If you don't have your T's crossed, if you don't have it technically correct, you can lose.
Yeah. Which means loss of more rent, loss of your fees that you're paying for your eviction. Golly, that's terrible. Well, we have Mr. Griffin here, extremely experienced attorney. He'd be more than happy to help you with your case here in San Diego. You can always call his law office. He's located here in sunny El Cajon, California. And his phone number is 619-440-5000. We are so grateful for you guys to be here with us. And there's actually so much more that we did not talk to you about on 3-Day Paper on our Quit. So please stay tuned to our next segment where we'll discuss additional elements and things that a landlord needs to follow in order to make sure that they have a good, solid case to win. Thank you.
Thank you for spending time watching this video. If you found this video helpful, be sure to share this video with your friends and loved ones. And like this video and comment below with any comments or any feedback that you might have. Also, check out the other informative videos on our YouTube channel and subscribe to our YouTube channel to continue receiving informative videos.